Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Booker, Hickenlooper, Kane, Leahy, Murray, Rosen, Smith, Stabenow, and Warnock. Senators voting in the negative: Cassidy, Collins, Cotton, Crapo, Inhofe, and McConnell. Mr. Heinrich, aye. Ms. Hassan, aye. Mr. Braun, no. Mr. Young, no. Mr. Bennett, aye. Ms. Duckworth, aye. Mrs. Gillibrand, aye. Ms. Hirono, aye. Mr. Ossoff, aye. Mr. Schatz, aye. Mr. Menendez? Aye. Mr. Reed? Aye. Ms. Warren? Aye. Mrs. Blackburn? No. Ms. Cantwell? Aye. Mr. Sanders? Aye. Ms. Ernst? No. Mr. Thune? No. Mrs. Feinstein? Aye. Mr. Cruz? No. Mr. Scott of Florida? No. Mr. Tuberville? No. Mr. Tillis? No. Mr. Tester? Aye. Mr. Casey? Aye. Mr. Rounds? No. Mr. Lujan? Aye. Mr. Schumer? Aye. Mrs. Shaheen? Aye. Ms. Baldwin? Aye. Mrs. Capito? No. Mr. Wyden? Aye. Mr. Carper? Aye. Ms. Cortez Masto? Aye. Mr. Coons? Aye. Mr. Kennedy? No. Mr. Lee? No. Mr. Hawley? No. Mr. Burr? No. Mr. King? Aye. Mr. Durbin, aye. Mr. Manchin, aye. Mr. Bozeman, no. Mr. Sullivan, no. Mr. Grassley, no. Mr. Daines, no. Mr. Marshall, no. Mr. Kelly, aye. Mr. Kramer, no. Mr. Wicker, no. Ms. Murkowski, no. Mr. Rubio, no. Mr. Paul, no. Mr. Lankford, no. Mr. Risch, no. Mr. Romney, no. Mr. Merkley, aye. Mr. Murphy, aye. Mr. Moran, no. Mr. Sass, no. Mr. Peters, aye. Mr. Portman, no. Mr. Cornyn, no. Mrs. Hyde-Smith, no. Mr. Brown, aye. Mrs. Fisher, no. Mr. Haggerty, no. Mr. Warner, aye. Mr. Barrasso, no. Mr. Cardin, aye. Ms. Sinema, aye. Ms. Lummis, no. Ms. Klobuchar, aye. Mr. Padilla, aye. Mr. Graham, no. Mr. Whitehouse, aye. Mr. Toomey, no. Mr. Blunt. Mr. Blunt, no. Mr. Shelby, no. Mr. Hoven, no. Mr. Scott of South Carolina, no. Mr. Blumenthal, aye. Mr. Van Hollen, aye. Mr. Markey, aye. Not yet. We gotta wait for the Veep. And I know. Here, I'll give you something.
All right.
Mr. Johnson, no.
morning. Okay. On this vote, the yeas are 50, the nays are 50. The Senate being equally divided, the Vice President votes in the affirmative and the motion is agreed to. The nomination is discharged and will be placed on the calendar.
No, I can. Mr. President.
Under the previous order, the Senate will resume legislative session. Majority Leader.
I move to proceed to executive session to consider calendar number 860.
The question is on the motion.
I ask for the yeas and nays.
Is there sufficient second? There appears to be. Clerk will call the roll.
Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Braun, Mr. Brown, Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mrs. Gilliran, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Mr. Rono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Lujan, Ms. Lummis. Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Otsoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Tuberville, Mr. Van Hollen, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Bennett, Coons, Durbin, Feinstein, Gillibrand, Klobuchar, Leahy, Lujan, Menendez, Murphy, Padilla, Romney, Schumer, Sinema, Stabenow, Tester, Whitehouse. Senators voting in the negative: Barrasso, Blackburn, Braun, Capito, Cornyn, Kramer, Crapo, Daines, Fisher, Graham, Grassley, Hoeven, Inhofe, Johnson, Kennedy, Lummis, Moran, Paul, Risch, Scott of Florida, Scott of South Carolina, Shelby, Thune. Mr. Warnock, aye. Mr. Sass, no. Mr. Cotton, no. Ms. Smith, aye. Ms. Warren, aye.
Yes, that's what I was concerned about. I mean, Padilla, no way.
Mr. Van Hollen, aye. Mr. McConnell, no. Mr. Booker, aye. Mr. Merkley, aye. Ms. Collins, aye. Mr. Tuberville, no. Mr. Rubio, no. Mrs. Shaheen, aye. Mrs. Murray, aye. Mr. Tillis, Mr. Tillis, no. Ms. Duckworth, Ms. Duckworth, aye. Ms. Cortez Masto, Ms. Cortez Masto, aye. Mr. Warner, Mr. Warner, aye. Marshall, Mr. Marshall, no. Mr. Haggerty, Mr. Haggerty, no. Mr. Markey, aye. Mr. Young, no. Mr. Ossoff, aye. Mr. Portman, no. Ms. Ernst, no. Mr. Toomey, no. Mr. Cruz, no. Mr. Wyden, aye. Mr. Blumenthal, aye. Mr. King, aye. Mr. Casey, aye. Ms. Murkowski, aye. Ms. Baldwin, aye. Mr. Rounds, no. Mr. Wicker, no. Mr. Blunt, no. Mrs. Hyde Smith, no. Mr. Brown, aye. Mr. Sullivan, no. Mr. Cassidy, no. Mr. Manchin, aye. Mr. Carper, aye. Mr. Heinrich, aye. Mr. Sanders, aye. Mr. Rono, aye. Mr. Cardin, aye. Mr. Hawley, no. Mr. Peters, aye. Mr. Burr, no. Ms. Hassan, Ms. Hassan, aye. Ms. Cantwell, Ms. Cantwell, aye. Mr. Lee, no. Mr. Reed, aye. Mr. Schatz, aye. Ms. Rosen, aye. Mr. Kelly, aye. Mr. Langford, no. Mr. Kane, aye. Mr. Bozeman. Mr. Bozeman, no. Mr. Hickenlooper. Mr. Hickenlooper, aye.
The yeas are 53, the nays are 47, and the motion is agreed to. The clerk will report the nomination.
Nomination, Supreme Court of the United States, Ketanji Brown Jackson of the District of Columbia to be an Associate Justice.
Mr. President,
Majority Leader.
I proudly and happily send a cloture motion to the desk.
Clerk will report.
Cloture motion, we, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close the debate on the nomination of Executive Calendar Number 860, Ketanji Brown Jackson of the District of Columbia to be an Associate Justice of the Supreme Court of the United States, signed by 20 senators as follows.
I ask consent the reading of the names be waived.
Is there objection? Without objection.
President.
The senator from Texas.
Mr. President, later this week, perhaps in a day or two, the Senate will vote on the nomination of Judge Ketanji Brown Jackson to serve as a member of the United States Supreme Court. Last week, I laid out the reasons for my opposition to this nomination, and yesterday, I voted against her nomination in the Judiciary Committee. But I want to make clear that my vote against Judge Jackson is not a rebuke of her legal knowledge, her experience, or her character. Judge Jackson is obviously very smart. She has vast practical experience, which I think is very useful. She's likable, and she's very clearly passionate about her work. The Senate's constitutional duty to provide advice and consent, though, requires us to look beyond Judge Jackson's resume and personality to understand her judicial philosophy and the lens through which she views her role as a judge. Certainly, the Senate must evaluate whether Judge Jackson will act fairly and impartially. We've also got to make a judgment whether she will leave her personal beliefs and her policy preferences at the door, and whether she will respect the bounds of her role as a judge or attempt to establish new judge-made law. This last point is absolutely critical in my view. The founders wisely established a system of checks and balances to ensure that no person or institution wields absolute power. The legislative branch, of course, makes law, the executive branch enforces the law, and the judicial branch interprets the law. We've each got our responsibilities under the Constitution. And while that's certainly a simplification of the duties of each of the three branches, it does illustrate that there are separate lanes or roles for each branch in our constitutional republic. And we talked about that during Judge Jackson's confirmation hearing. The judge says she understands the importance of staying in her lane. She used that phrase many times during the confirmation hearing. She said she would not try to do Congress's job, making laws. But over the years, and I think this is a blind spot for Judge Jackson and frankly, many on the bench, particularly at the highest levels, over the years we've come to see a pattern of judges who embrace the concept of judge-made law. In other words, it's not derived from a statute passed by the Congress, it's not derived from the text of the Constitution itself, but rather it's made as a policy judgment without any explicit reference in the Constitution itself. Now that, I believe, is judicial policymaking or legislating from the bench. The Supreme Court over the years has developed various legal doctrines like substantive due process. That's a little more opaque, I would think, to most people than judge-made law, but basically it's the same thing. It's a doctrine under which judges create new rights that are not laid out in the Constitution. It shouldn't matter if a person ultimately agrees or disagrees with this new right. If you like the result, well, you're liable to overlook the process by which the judges reached a decision. But if you disagree with it, then clearly it's a problem to have judges unelected, unaccountable to the voters, making policy from the bench, no matter what it's called. It's deeply concerning, I think, and it should be, to all Americans to have 9 unelected and ultimately unaccountable judges make policies that affect 330 or so million people. And they can have no say-so about it at all. They can't vote for them, they can't vote them out of office, they can't hold them accountable. In fact, the whole purpose of judicial independence is so judges can make hard decisions, but they have to be tethered to the Constitution and the law, not made up out of whole cloth. No judge is authorized under our form of government to rewrite the Constitution to their liking or impose a policy for the entire country simply because it aligns with their personal belief or their policy preferences. As our founders wrote in the Declaration of Independence, governments are instituted among men, deriving their just powers from the consent of the governed. When judges find unenumerated and invisible rights in the Constitution and issue a judgment holding in essence that all state and federal laws that contradict with their new judge-made law is invalid and unconstitutional, there's no opportunity for anybody to consent to that outcome, like you would if you were a member of the Senate or a member of the House. People could lobby us, they could call us on the phone, they could send us emails, use social media to try to influence our decision. They could recruit somebody to run against us in the next election. They could vote us out of office if they didn't like the outcome. But none of that would apply to life-tenured, unaccountable federal judges making judge-made law at the highest levels. No consent of the governed, no legitimacy which comes from consent. Abraham Lincoln made clear that it's the concept of consent that is the foundation for our form of government. He said famously, "No man is good enough to govern another man without that man's consent." Of course, he used that in the context of slavery, and he was right, but it has broader application as well. As I said, when it comes to the executive and legislative branches, it's easy to see how consent and the legitimacy that flows from that comes into play. Voters cast their ballot for senators, for members of the House, for the president. Once a person is office, voters conduct what you could describe as a performance evaluation. The next time that person's on the ballot, voters determine whether that person should remain in office or be replaced by someone new. But again, that's not true of the judicial branch, which highlights and demonstrates why the judicial branch is different, why it shouldn't be a policymaker, why judges shouldn't be pronouncing judge-made law that's not contained in the Constitution itself. It's important that our courts remain independent and be able to make those hard calls, but even people like Judge Breyer, who Judge Jackson will succeed on the Supreme Court, has written books worried about the politicalization of the judiciary. And I think that's one reason why our judicial confirmation hearings can get so contentious. Witness Brett Kavanaugh's confirmation hearing, which was a low point, I believe, for the Senate Judiciary Committee and for the Senate as a whole. But people wouldn't get so exercised over these nominations if people were simply calling balls and strikes like the umpire at a baseball game. Judges should be umpires. Judges should not be players. So justices on the Supreme Court are not held accountable at the ballot box, and they aren't evaluated every few years for their job performance. They're nominated by the president and confirmed for a lifetime appointment. When justices engage in blatant policymaking, it takes away the power of we the people to decide for ourselves and hold our government accountable. It speaks to that statement in the Declaration of Independence that says government derives its just powers from the consent of the governed. But that's totally missing when it comes to judge-made law and identifying new rights that are nowhere mentioned in the Constitution. Again, I understand when you like the outcome as a policy matter, you're not liable to complain too much. But we should recognize this over the course of our history as a source of abuse by judges at different times in our history. And we've seen the horrible outcomes of things like Plessy versus Ferguson, where the Supreme Court, without reference to the Constitution itself, using this doctrine of substantive due process, said that separate but equal was the answer for the conflict between the rights of African American school children and the rest of the population. They said it's okay, you can satisfy the Constitution if you give them separate but equal educations. Well, of course, that's a shameful outcome, and we would all join together in repudiating that kind of outcome. And thankfully, years later, too many years later, Brown versus Board of Education established that the separate but equal doctrine was overruled. And that's as it should be. But the point I'm trying to make here is whether it's the court's decisions on abortion or the right to marry a same-sex partner or separate but equal, or even things like the Dred Scott decision, which held that African-American fugitive slaves were chattel property, or in the famous Lochner case, where the New Deal justices struck down an attempt by the government to regulate the working hours of bakers in New York. All of these involved the use of this substantive due process doctrine as a way to cover up and hide the fact that it was judges making the law and not the policymakers who run for office. I'm also afraid that Judge Jackson did not always adhere to her own admonition that judges should stay in their lane. In the case Make the Road New York versus McAleenan, the American Civil Liberties Union challenged a regulation involving expedited removal of individuals who illegally cross our borders and enter into the country. The Immigration and Nationality Act gives the Department of Homeland Security Secretary, and I quote, sole and unreviewable discretion, close quote, to apply expedited removal proceedings. Judge Jackson, who presided over the case challenging that rule, ignored the law. She went beyond the unambiguous text to deliver a political win to the people who brought the lawsuit. She barred the Department of Homeland Security from using expedited removal proceedings to deter illegal immigration. She stopped the administration from enacting immigration policies it had clear authority to implement according to the black letter law. Unsurprisingly, that decision was appealed and ultimately overturned by the D.C. Court of Appeals. But this is an example of not staying in your lane and not deferring to Congress the authority to make the laws of the land when the Congress has been unambiguously clear. So ultimately, I believe that demonstrates a willingness to engage in judicial activism and achieve a result, notwithstanding the facts and the black letter law in the case, and to disregard the law in favor of a political win for one of the parties. But this is just exactly what I started off talking about. This is the opposite of consent of the governed, when judges ignore the laws passed by Congress, even when congressional intent is clear. Unfortunately, that wasn't the only example of activism in Judge Jackson's decisions. We've heard a lot about this, and I think it was an entirely appropriate subject for questions and answers. Judge Jackson's an accomplished and seasoned lawyer and judge, and she knows how to answer hard questions. During sentencing hearings, Judge Jackson has said she disagreed with certain sentencing enhancements for policy reasons. That's the word she used, for policy reasons, and she chose to disregard its application. That's not staying in your lane. She also used a compassionate release motion to retroactively slash a dangerous drug dealer's criminal sentence because she didn't like that the government brought a mandatory minimum drug charge, even though the government had every right to do so under the applicable law. The promise of Equal justice under law requires judges to follow the law regardless of their own personal feelings about the policies. Justice Scalia famously said, if a judge hasn't at one time or another in his or her career rendered a judgment that conflicts with their own personal preferences, then they're probably not doing their job right. It's absolutely critical for our Supreme Court justice to not only acknowledge but to respect the limited but important role that judges play in our constitutional republic. They shouldn't allow politics or policy preferences to impact their decisions from the bench, and they can't use their power to invalidate the will of the American people based on invisible rights that aren't actually included in the Constitution itself. In 1953, Judge Robert Jackson observed that the Supreme Court is not final because it's infallible, but it's infallible only because it's final. In other words, the recourse that we, the people, have when judges overstep their bounds when it comes to constitutional interpretation is to amend the Constitution itself, something that's only happened 27 times in our nation's history, and it's a steep hill to climb, to be sure. But it's important for the legitimacy of the Supreme Court itself for the judges to be seen as staying in their lane and interpreting the law, not making it up as they go along. I'm reminded of another quote about the scope of the judiciary's duties and powers. In 1820, Thomas Jefferson wrote, "To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." Once again, our founding fathers, had the wisdom to establish 3 branches of government that share power to avoid any single person or institution from wielding absolute power. And to ensure that we maintain the proper balance of power, justices need to stay in their lane and interpret the law, not make the law, particularly when the voters have denied consent from them for doing so. So to summarize, Mr. President, to ensure that we maintain the proper balance of power under our Constitution, judges must only interpret the law, and they can't allow activism to bleed into their decisions. And they can't ignore black-letter law. And they can't use doctrines like substantive due process to hide the fact that they're making up new rights that aren't contained anywhere in the written Constitution itself. As I've said before, I fear that if confirmed, Judge Jackson will attempt to use her vast legal skills to deliver specific results and stay out and get outside of her lane by making judge-made laws that are not supported by the text of the Constitution itself. As I said in the Judiciary Committee, and I'll say again, when the time comes to vote on Judge Jackson's nomination here on the Senate floor, I will once again vote no for the reasons I just stated.
Mr. President.
Senator from Missouri.
Mr. President, I rise today to urge the Senate to take action to crack down on child pornography offenders and to protect our children. This is a growing crisis and it is one that is near to the heart of every parent in America. I can attest to that as a father of 3 small children myself. I've got a 9-year-old, a 7-year-old, and a 16-month-old baby at home. But I can also attest to it as a former prosecutor. As the Attorney General for the state of Missouri, one of the first things I did was to establish a statewide anti-human trafficking initiative and task force, because what I saw as Attorney General of my state was that human trafficking, including, unfortunately, child sex trafficking, is an exploding epidemic in my state and around our country. Children are exploited, children are trafficked, and those who work in this area, those who prosecute in this area, law enforcement, who work day in and day out will tell you that the explosion of child pornography is helping to drive this exploding epidemic of child sexual exploitation and child sex trafficking. The problem is that child porn itself is exploding. A New York Times investigative report found that in 2018 there were 45 million images of children being sexually exploited available on the internet. 45 million. Just a few years before, it had been 3 million. In 2018, 45. Then last year, the National Center for Missing and Exploited Children found that that number had grown to 85 million. 85 million images on the internet of children being brutally sexually exploited. And as every prosecutor and every law enforcement advocate and every law enforcement agent who works in this area will tell you, that explosion of this material, which, by the way, is harmful in and of itself, is exploitative in and of itself, is driving a crisis of child exploitation and child sex trafficking in this country. Now, the nomination of Judge Ketanji Brown Jackson to the Supreme Court has helped bring this issue front and center. Her record of leniency to child sex offenders has been much the center of her hearings, and it has startled the public. A recent Rasmussen survey found that following her hearings, 56% of all respondents said that they were troubled by her record on child sex offenders. That included 64% of independents. And they're right to be troubled. Her record is indeed startling. In every case involving child pornography where she had discretion, she sentenced below the federal sentencing guidelines, below the prosecutor's recommendations, and below the national averages. We now know that the national average for possession of child pornography, the national sentence imposed on average, is 68 months. Judge Jackson's average, 29.3 months. The national average sentence for distribution of child pornography, 135 months. Judge Jackson's average, 71.9 months. In fact, it's true for criminal sentencing across the board. The national average of all criminal sentences imposed in the United States, 45 months. Judge Jackson's average, 29.9 months. This is a record of leniency, in the words of the Republican leader, leniency to the extreme to child sex offenders and on criminal matters in general. But, we are told, and have been told for weeks on end now, it's not really her fault. We were told by the White House and Senate Democrats that it's not her fault because those federal sentencing guidelines that she, in every case where she could, went below, those guidelines aren't binding. Thanks to a decision of the Supreme Court by Justice Breyer, Justice Stevens, those guidelines are only advisory. And so we were told repeatedly that if we really want to get tougher sentences for child porn offenders, then we're going to have to change the law. In fact, I see my friend Senator Durbin here today, the chairman of the Judiciary Committee. He said this to me multiple times during the committee. On March the 22nd, he said to me, "I hope we will all agree that we want to do everything in our power to lessen the incidence of pornography and exploitation of children. I want to tell you, Congress doesn't have clean hands. We haven't touched this now for 15, 16, or 17 years. Senator Durbin went on, "We've created a situation because of our inattention and unwillingness to tackle an extremely controversial area in Congress and left it to the judges. I think we have to accept some responsibility." And he went on, "I don't know if you, meaning me, have sponsored a bill to change this. I'll be looking for it. If we're going to tackle it, we should." Well, I agree with that, 100%. I agree we should tackle it. This is the time to tackle it, and I'm here to do that today. I'm proud to sponsor and introduce legislation along with my fellow Senators Mike Lee and Tom Tillis and Rick Scott and Ted Cruz to get tough on child porn offenders. Now, let's be clear. When Congress wrote the child pornography federal sentencing guidelines, and it is Congress that wrote them substantially way back in 2003, when Congress wrote them, they wanted them to be binding. Congress meant for these guidelines to bind federal judges. The Supreme Court struck that part of the guidelines down. Now it's time to put it back into place. My bill would create a new mandatory minimum sentence of 5 years for every child porn offender who possesses pornography. 5 years. If you do this crime, you ought to go to jail. It would make the guidelines binding for any and all facts that are found by a jury or found by a judge in a trial. Restore the law to what Congress intended back in 2003. Take away discretion from judges to be soft on crime and get tough on child sex offenders. That's what this bill would do. Now, I've called this bill the PROTECT Act of 2022 because it's modeled on the PROTECT Act of 2003 when Congress wrote these guidelines. And I just note for the record that I believe every senator voted for it back in 2003, including the chairman of the Judiciary Committee, Senator Durbin, and every member of the Judiciary Committee, Republican and Democrat, who was serving at the time. That act back in 2003 toughened penalties for child porn offenders, made the guidelines mandatory, and explicitly took away discretion from judges to sentence below the guidelines. I think it was a pretty good law, and I think now is the time to act. Our children are at risk. The epidemic of sexual assault, sexual exploitation, and victimization is real. And let's be clear on what child pornography is. It is an industry that feeds on the exploitation of the most vulnerable members of our society, that feeds on the spectator sport of child abuse and child victimization. If you have a lot of images of child pornography, you ought to go to jail for a long time. If you possess child pornography, you ought to go to jail for at least 5 years. And yes, it is time to tell every judge in America to get tough on child porn. That's what this bill would do. And I just urge the Senate now to take this opportunity to act. And so, as if in legislative session, I ask unanimous consent that the Committee on the Judiciary be discharged from further consideration of S. 3951 and the Senate proceed to its immediate consideration. I further ask that the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid upon the table.
Is there objection?
Mr. President,
Majority Whip.
reserving the right to object, I have to ask myself, why now? Why does the junior senator from Missouri bring this bill to the floor of the United States Senate today? When you think back, this matter has been considered. Originally, the guidelines were considered in 1984. The question of child pornography came back to us in 2003. In 2005, there was a Supreme Court case about applying the guidelines on sentencing to these types of cases, a case known as Booker. We know that in 2005, that decision was handed down. We know in 2012, the Sentencing Commission said to Congress and to the world, you need to do something here. These guidelines that you promulgated don't reflect the reality of today. We know as well that the guidelines were written, some were written in an era when the materials we're talking about were physical materials, and we now live in a world of internet and access to not just tens and hundreds, but thousands of images, if that is your decision. And all these things have happened, and we come here today. Today. I don't know exactly how many years the senator from Missouri has been in the Senate, but to my knowledge, this is his first bill on this subject that he has presented in the last few weeks. And I wonder why. Why now? Are there valid questions about sentencing guidelines? Certainly, there's no question about it. I said as much, and he quoted me. The Sentencing Commission told us over a decade ago, in 2012, you've got a problem here. The world has changed, and the law doesn't reflect it. But this is the first time, to my knowledge, that the senator from Missouri or any Republican senator has tried to enact legislation on the subject. Why now? Well, I know why. He said as much. It's because we are now considering the nomination of Judge Ketanji Brown Jackson to the Supreme Court. And this senator has suggested over the course of the last 2 weeks in hearings before the Senate Judiciary Committee that somehow this judge aspiring to the Supreme Court is out of the mainstream when it comes to sentencing in child pornography cases. It's no coincidence that the senator from Missouri comes to the floor today while Judge Jackson's nomination is pending on the Senate calendar and has been discharged from our committee by a bipartisan vote of the Senate last night. It's no coincidence that he is raising this issue within hours or days before her confirmation vote. It's one more very transparent attempt to link Judge Ketanji Brown Jackson's confirmation with this highly emotional issue of federal sentencing when it comes to child pornography or child exploitation. There are some political groups, at least one well-known political group, that manufactures theories about child pornography and pedophilia and the like, and even inspires deadly reactions to them, and they're cheering this on. I've seen their reaction already this morning in the newspaper. They're watching this and hoping that someone can keep this issue alive on the floor of the United States Senate for them. The senator from Missouri has even gone so far as to make the outrageous claim that this woman, Judge Jackson, the mother of 2 wonderful girls who I had a chance to meet, a mother who comes to this issue not only as a judge, but as the daughter and niece of law enforcement officials who've been part of her family. In the words of the senator from Missouri, that this woman, quote, endangers children, close quote, endangers children. I'll yield when I'm finished. One conservative former prosecutor called Senator Hawley's charges, quote, meritless to the point of demagoguery. I've read so many reviews of the senator's charges against this judicial nominee. Not one of them gives him any credence. They basically say what you are dealing with here is a complicated area of the law, controversial area of the law, and to try to ascribe to this one nominee these motives, these outcomes, is baseless and meritless. Consider this. How can this judicial nominee possibly have the endorsement of the largest law enforcement organization in America, the Fraternal Order of Police, the endorsement of the International Association of Chiefs of Police, and many other law enforcement groups? How could she possibly have all that and be as wrong on a critical issue as the senator from Missouri has asserted? How is it possible that the American Bar Association took a look at all of her contacts as a judge, as a lawyer, as a law student, came up with 250 individuals who knew her personally, appeared in court with and against her, judged her in her individual capacity as a lawyer? How can the American Bar Association interview those 250 and find no evidence of the charges that have been made by the senator from Missouri? How is it possible that they would review all this and miss such a glaring fact? They didn't. They told us under oath that they asked point blank, is her sentencing standard soft on crime, different than other judges? The answer was no. No. And the net result of it was the American Bar Association found this nominee, whom the senator from Missouri charges with these outrageous claims, they found her to be unanimously well qualified. Unanimously well qualified. And yet the senator from Missouri believes that he's discovered something that the whole world's missed. Unfortunately, he's wrong, and he doesn't admit it. When Judge Jackson is confirmed to the Supreme Court, and I pray that she will be later this week, it will be in part because she is a thoughtful, dedicated person who has worked as a judge for over 10 years. She has published almost 600 written opinions. She has had 100 cases where she has imposed criminal sentences. and a dozen or plus cases involving children. What the senator from Missouri has done is cherry-pick arguments from one small part of her service on the bench that has been debunked across the board. But let me say it again. Judge Jackson's sentences were appropriate exercises of discretion as a judge applying the law to the facts in difficult cases. And it's interesting to me how the senator from Missouri has carefully drawn lines to exclude Trump appointees to the bench who've done exactly what this judge has done as well, so-called deviate from the guidelines when it came to sentencing. In fact, one judge from his state, from the Eastern District of Missouri, whom he has personally endorsed as a good judge and may well be, has followed the same practice as this judge. Did he raise that at all in the Senate Judiciary Committee about the Missouri judge that was doing the same thing as Judge Jackson? No, nothing. There is nothing about these judges that is deviating from other than accepted practices. When 70 to 80% of the judges across America are using the same standard, Judge Jackson is in that mainstream, along with judges that this senator from Missouri has endorsed. If this issue needs to be addressed, and I believe it does, we can do so if we do it carefully, and we should do it carefully. Make no mistake, I don't back off from my words. As a father, as a grandfather, as a caring parent, I sincerely consider this to be one of the most serious crimes. The exploitation of children. I can't think of anything worse. And the pornography issue certainly is out of control because of the internet and because of those who are making a dollar on it. And we should take it very seriously, very seriously. It changes and destroys lives. But let's make sure we do this in the right way. What have we done on the Senate Judiciary Committee? It's great for the chairman to stand on the Senate floor and talk about the issue. Well, what have you done, Senator? Well, let me tell you what I've done, and I think the senator from Missouri knows it. We've done what we can to address this issue from many different angles. The committee held a hearing on the FBI's failure to properly investigate allegations against Larry Nassar for assaulting young athletes, Olympic gymnasts included, which enabled the abuse of dozens of additional victims. We called them on the carpet, we put them under oath, we brought the testimony forward. We didn't back away from the issue of child abuse. Following that hearing, I introduced the Eliminating Limits to Justice for Child Sex Abuse Victims Act with Senator Marsha Blackburn, a Republican from Tennessee. The Senate has now passed this bipartisan legislation, which would enable survivors of child sex abuse to seek civil damages in federal court, no matter how long it's taken the survivor to disclose the facts of the case. And the committee has unanimously reported a bill which the senator from Missouri knows well, the Earn It Act, legislation he has co-sponsored with Democratic Senator Blumenthal that will remove blanket immunity for the tech industry for violations of laws relating to online child sex abuse material. I have no apologies for our approach on this, and there is more work to be done. But I want to tell you, I'm tempted to leave it just at that, but for one thing I'm concerned about. Our federal sentencing guidelines have been advisory, not mandatory, since the Supreme Court's 2005 ruling in the Booker case. This bill, now being offered on the floor in a very quick fashion by the senator from Missouri, this bill attempts to create mandatory sentencing guidelines for a single category of offense. It's not clear whether it passes the constitutional test of Booker. It could be a waste of time. We don't need to waste time in a critical area of the law that has been so controversial and has been considered and reviewed over decades. Even so, it's a dangerous slope to go down. Imagine a world where every time it was politically advantageous, whether there was a Supreme Court nominee or a headline in the paper, that some senator could come forward, disagree with a federal judge on a particular case, and say, let's pass a mandatory minimum sentencing guideline to take care of the matter. That is no way to approach the law in a fashion that is used for deterrence and punishment. We need to be thoughtful about it. A subject of this seriousness, this gravity, deserves more than a drive-by on the floor of the United States Senate. I invite my colleague to do his work on this issue as we all should, the work that is required, the work that is required by the seriousness of this matter, and I object.
Mr. President.
Objection is heard.
Mr. President.
Senator from Missouri.
The senator asks why now? Why act now? Because it's a crisis now. Because there are 85 million images of children being exploited on the internet now. Because child exploitation is exploding in this country now. And today the senator lays bare on this floor the bait and switch that he and his colleagues have employed. They say, oh, Judge Jackson, it's not her fault. You should act in the law to change the law. But when we come to change the law and to do what this Congress did in 2003, to do it now in 2022, a measure that Senator Durbin supported in 2003, he says, oh, no, we don't need to act now. Why do it? It's rushed. It's too hurried. Let's do it later. Let's think about it longer. And then we hear recited again the bizarre claims that somehow child pornography is a conspiracy theory. This is something that the Senate Democrats, including the chairman, have repeated over and over and over, led by the White House. The idea that child exploitation is a conspiracy theory? I just invite you to look any parent in America in the eye and tell them that the exploitation of children is a conspiracy theory, or any law enforcement agent, or any prosecutor, or anyone who is working on the exploitation to combat the exploitation of children in this country. No, it's a crisis, and it's real. And the fact that the Senate hasn't acted till now is, I think, shameful for the Senate. But why wait another day? Now, I look forward, if the senator is serious, he does hold the gavel in the Judiciary Committee. We could mark this bill up. We could hold hearings. We could take action. I'd invite him to co-sponsor this bill. He voted for it in 2003. Let's have hearings then, if we can't vote on it today, if we can't debate it today. Let's have hearings. Let's mark it up. Let's take it seriously. I'll wait. I suspect I'll be waiting for an awfully long time. Here's the bottom line. I am not willing to tell the parents of my state that I sat by and did nothing. I am not willing to dismiss child exploitation as just some conspiracy theory. I am not willing to abandon the victims of this crime to their own devices and say, good luck to you. No, I'm not willing to do that. And nor am I willing to excuse Judge Jackson's record of leniency that does need to be corrected. She should not have had the discretion to sentence leniently in the extreme as she did, nor should any judge in America, in my view. So what's sauce for the goose is sauce for the gander. We should fix it for everybody across the board. And we can begin by acting as we did in 2003. So I'm disappointed, but I can't say that I'm surprised that this measure has been objected to today. And all I can say is I pledge to my constituents, I pledge to the parents of my state, and yes, to the victims of my state, that I will continue to come to this floor, that I will continue to seek passage of this act until we get action from this Senate to protect children and to punish child pornographers. I yield the floor.
Mr. President,
Majority Leader.
so after 27 minutes of debate on the floor of the Senate, the senator now believes we're prepared to change the law that has been debated for decades. He has put in a bill introduced 7 days ago. It's been 7 days he's had the passion for this issue, enough to introduce legislation. If you want to take on a serious issue, take it on seriously. And that means doing the homework on it. Yes, have a hearing. Of course, have a hearing. We want to make sure that people from the Sentencing Commission and others are part of this conversation. It isn't just a matter of throwing charges out against a nominee. And if you want to be serious about it, then admit the obvious. 70 to 80% of federal judges struggle with the same sentencing that we have set down, and in light of Supreme Court decisions, we understand that. Ask for order, Mr. President.
Ask for order. There was no response to begin with to the senator, so let's move forward.
So I would say, Mr. President, that as far as I am concerned, this is a serious matter that should be taken seriously. You don't become an expert by 7 days ago introducing a bill and say, I've got it. Don't change a word of it. Make it the law of the land. Make it apply to every court in the land. No, we're going to do this seriously. We're going to do it the right way. And we're going to tackle an issue that has been avoided for more than 2 decades when you look at the history of it. I find this reprehensible, the pornography, the sexploitation of children. There are no excuses whatsoever. But I'm not going to do this in a slipshod, make a headline manner. We're going to do it in a manner that is serious, that we work with prosecutors, defenders, judges, sentencing commission, and get it right. It's time to get it right. We wrote this law some 19 years ago, before the internet was as prevalent in society as it is today. Let us be mindful of that as we attack this problem and address it in a fashion that is befitting the Senate and the Senate Judiciary Committee. I yield the floor.
Mr. President.
Senator from Missouri.
Mr. President, the senator from Illinois says that Congress hasn't acted in 2 decades. That's true. I haven't been here for 2 decades. He has. There is no excuse to not take action now. There is no excuse to not act on this problem when we know what the solution is. So listen, if the senator is saying today, if he's committing today to holding hearings and marking up a bill to toughen the child pornography laws, to make mandatory the sentencing guidelines, that's fantastic. I'll take him at his word. I look forward to seeing those hearings noticed and to seeing that markup noticed. And I hope it'll be forthcoming. I'm here to make a prediction. I think we'll be waiting a very long time. Because let's not forget what his party and the Sentencing Commission, stacked with members of his party, have been recommending. It's not been to make child sentences tougher, child pornography sentences tougher. They've wanted to make them weaker. What the Sentencing Commission has recommended with its liberal members for years now is to make them weaker. That's what Judge Jackson has advocated. She also wants to change the guidelines to make them weaker. I think that's exactly the wrong move. And that's why the senator was here to block this effort today. He doesn't want to see tougher sentences. He doesn't want to talk about this issue. He wants to sweep it under the rug. I'm here to say I won't let that happen. I'll be here as long as it takes. I'll be agitating for this in the Senate Judiciary Committee as long as it takes until we get justice for the victims of child pornography and child exploitation. I yield the floor.
Under the previous order, the Senate stands in recess until 2:15 p.m.
Senate will come to order. Senator from Arkansas.
The Senate will soon vote on the nomination of Judge Ketanji Brown Jackson to be Associate Justice of the Supreme Court. I will vote against her nomination. Judge Jackson may be a fine woman, but she is a dangerous judge. She built her career as a far-left activist, and it didn't change when she put on a robe 10 years ago. She personifies activism from the bench. She has crusaded to undermine criminal sentences, and she cannot be trusted to interpret the law or the Constitution as written. Judge Jackson's record makes clear that her brief stint as a criminal defense attorney wasn't motivated merely by a devotion to equal representation of all. It was part of a deep commitment to leniency for criminals. Indeed, she has continued to act as a de facto lawyer for criminals from behind the bench, as she did from in front of it. Judge Jackson's average sentences for criminals are 34% lighter than the national average for criminal cases, and 25% lighter than her own court's average, the D.C. District Court. Disturbingly, some of the most sensational examples of her soft-on-crime attitudes are cases involving child pornographers. She has given more lenient sentences than recommended by the sentencing guidelines in every single child pornography case where the law allowed it. Every single one. Every time. Individuals sentenced by Judge Jackson for child pornography possession receive, on average, 57% lighter sentences compared to the national average. For child pornography distribution, the sentence is 47% lighter than the national average. These aren't just numbers, these are predators. And they go on to commit more of the most heinous crimes imaginable because Judge Jackson lets them off so easy. In one case, Judge Jackson gave child pornographer Wesley Hawkins just 3 months in prison when the sentencing guidelines recommended 8 to 10 years. 3 months versus a recommended 8 to 10 years. Judge Jackson even gave him a sentence that was 1/6 as long as what her own probation office recommended. And a few years later, when Hawkins should have still been in prison for his original offense, he did something else. They got him 6 more months in custody. That's twice as long as his original sentence. When all 11 Republicans on the Judiciary Committee sent a letter asking for details of what happened to justify this new sentence, Judge Jackson refused to provide any further information. So much, I guess, for looking at her record, as she urged us to do. Her leniency isn't limited to child pornographers either. In 2017, Judge Jackson apologized. She apologized to a fentanyl kingpin, his own words, kingpin, because she couldn't find a way to sidestep the law to give him less than the mandatory minimum sentence. She was very sorry that she had to give him such a long sentence. But I guess where there's a will, there's a way. A few years ago, she found a way to re-sentence this self-described kingpin below the mandatory minimum sentence. Through a completely made-up reinterpretation, Judge Jackson made the First Step Act retroactive for this fentanyl kingpin, something Congress had explicitly tried to avoid when it passed the law. This was judicial activism, plain and simple. In her testimony, Judge Jackson claimed that there were no victims in that case. She's wrong. Fentanyl trafficking is not a victimless crime, and anyone who doesn't understand that doesn't belong on the Supreme Court. In another case, Judge Jackson granted compassionate release to a man who brutally murdered a deputy U.S. Marshal on the steps of a church at a funeral. While in prison, this cop killer threatened prison staff and was caught in possession of a dangerous weapon, not exactly a model inmate. He was repeatedly denied parole, yet Judge Jackson granted him compassionate release because he had high blood pressure. In yet another case, a career criminal assaulted a deputy U.S. Marshal with a deadly weapon while resisting arrest. This was the third time that this criminal had assaulted law enforcement officers, the very officers who risked their life to keep judges like Judge Jackson safe. Judge Jackson didn't just sentence him below the government's request or the sentencing guideline range. She gave the criminal less time than even the criminal himself had advocated. You can't make this stuff up. In 2013, a sex offender who had repeatedly raped his 13-year-old niece was arrested for falsifying sex offender registration records to avoid telling the government where he was living and that he was working at a daycare. The government sought a 2-year prison sentence, but Judge Jackson gave him just 1 year instead. And during that second year, when he would have been in prison, he tried to rape again and then bribed the victim with $2,500 to recant her testimony. This dangerous sex offender was convicted of obstructing justice, yet when presented with a do-over, Judge Jackson sentenced him to just 24 months in prison for those violations. Now, I wish I could say this was to her credit because, to be fair, 24 months was the sentence recommended by the government, but she ensured her order in that sentence would run concurrently with the sentence in local D.C. jail, so he'd only end up serving 1 year instead of 2. Judge Jackson habitually sympathizes with criminals over victims. These are just a few of the many outrageous cases in Judge Jackson's record. The takeaway is crystal clear. If you're a criminal, you'd be lucky to have your case assigned to Judge Jackson. If you're a victim or anyone else seeking justice, you should hope that your case is assigned to literally any other judge. As a trial judge, though, Judge Jackson could only help one criminal at a time. As a Supreme Court justice, she would be able to benefit criminals nationwide in all cases. Judge Jackson's far-left activism extends beyond crime as well. Not only did she engage in what the Sixth Circuit called an end run around Congress to retroactively reduce the sentence of that fentanyl kingpin I mentioned earlier, she also worked to strike down a Trump administration order expediting the removal of illegal aliens on equally specious legal grounds. The law passed by Congress granted the Department of Homeland Security, quote, sole and unreviewable discretion to decide which illegal alien should be subject to expedited removal. Nonetheless, Judge Jackson inserted herself to strike down what she called, quote, a terrible policy by the Department of Homeland Security. Well, I regret to inform Judge Jackson it is not her role in our system to decide whether immigration policy is good, bad, terrible, or any other adjective she wants to use, only whether it is lawful and authorized by law. And of course, the D.C. Circuit Court, which is not exactly a hotbed of conservative jurists, agreed and reversed Judge Jackson's decision, noting that there are, quote, could hardly be a more definitive expression of congressional intent than the language in that law that she disregarded. But Judge Jackson didn't care. She had an anti-Trump op-ed that she wanted to write in the form of a judicial opinion. Judge Jackson has also shown real interest in helping terrorists. Now, it's true that you shouldn't judge a lawyer for being willing to take on an unpopular case, but you can certainly learn something about a lawyer from the cases they seek out. And for Judge Jackson and her friends in the liberal legal profession, these cases were not unpopular at all. Judge Jackson represented 4 terrorists as a public defender, one of whom she continued to represent in private practice, voluntarily. And she voluntarily filed multiple friend of the court briefs on behalf of terrorists while in private practice. To make matters worse, she apparently didn't even bother when she was representing these terrorists. She didn't bother to establish a reasonable belief that what she filed with the court was factually true. 3 of her 4 case filings were identical, word for word, comma for comma. She alleged identical facts and legal arguments in each case. The only differences between the briefs were the names and the case numbers. In every one of those cases, she claimed the terrorist had never had any affiliation with the Taliban or al-Qaeda. And in every one of those cases, she accused the Bush administration and American soldiers of war crimes. And who were these supposed innocent victims of American war crimes who, according to Judge Jackson, had nothing at all to do with terrorism? No siree, nothing at all. Well, one of her clients designed the prototype shoe bomb that was used in an unsuccessful attempt to blow up a passenger airplane. Another planned and executed a rocket attack on U.S. forces in Afghanistan. And a third was arrested in a raid on an al-Qaeda explosives training camp. Yet in every case, she claimed that none of them had anything to do with terrorism. Not a thing. Totally innocent, just goat herders who were picked up by marauding American troops. You know, the last Judge Jackson left the Supreme Court to go to Nuremberg and prosecute the case against the Nazis. This Judge Jackson might have gone there to defend them. Judge Jackson also refused to answer one common sense question after another. For example, when Senator Blackburn asked her what a woman is, she pretended not to know. I asked her who has more of a right to be in the United States, new citizens who followed the rules or illegal aliens whose very first act in the United States was to break our laws. Judge Jackson refused to answer. And when I asked a simple question of Judge Jackson whether releasing Guantanamo Bay terrorists would make us more safe or less safe, she again pretended not to know the answer, even though it's published by the Biden administration. I also asked Judge Jackson if criminals were more or less likely to commit a crime if they knew that they would be caught, convicted, and sentenced. I asked this pretty basic question at least 3 times. It was not a hard question, and yet again, she refused to answer. Judge Jackson also refused to say whether packing the Supreme Court was a bad idea, even though the judge for whom she clerked and seeks to replace Justice Breyer and the late sainted Justice Ruth Bader Ginsburg, neither of whom are known for their conservative views, were both willing to publicly denounce such court-packing schemes by the Democrats. Judge Jackson may feign ignorance, not because she doesn't know these answers, but because liberal judicial philosophy is all too often based on denying reality. As a judge, Judge Jackson has denied that reality again and again. Judge Jackson will coddle criminals and terrorists, and she will twist or ignore the law to reach the result that she wants. That's not what we need in a Supreme Court justice, and that's why I will be voting against her nomination. Madam President, yield the floor.
Madam President.
Senator from South Dakota.
Thank you, Madam President. Madam President, if a budget is a set of priorities, here are the president's: an expanded federal government, a diminished national defense, higher gas prices, and an open border. Those are the priorities reflected in the budget the President released last week, which contains pretty much what you'd expect: more taxes, more spending, more borrowing, and in all likelihood, more inflation as a result. Madam President, big taxes and big spending have been the agenda for President Biden since he took office. After signing a $1.9 trillion spending spree in March of 2021 that helped create the worst inflation in 40 years, President Biden spent much of last year pushing for still more spending to fund his vision of an expanded federal government. And his 2023 budget is just more of the same. The President's budget would increase average yearly spending by 66%. as compared to the average of the last 10 years. 66%. That is a staggering spending increase. Yearly federal spending under the Biden budget would average $7.3 trillion. Now, to put that in perspective, Madam President, total average spending in 2019 was $4.4 trillion. Now, how is the President going to pay for this, if he even can? Taxes. A lot of taxes. The biggest tax increase in history in dollar terms, according to Bloomberg. The President, of course, attempts to sell the tax hikes he's proposing as something that won't affect ordinary Americans. Well, that couldn't be more wrong. That corporate tax hike that he keeps pushing, one study estimates that 31% of the corporate tax is borne by consumers. Another big portion of it is borne by labor, otherwise known as ordinary, hardworking Americans. High prices, fewer jobs, lower salaries, we can expect to see all that and more if the President hikes taxes on companies. And I haven't even mentioned the fact that a corporate tax hike may end up hurting private pensions and the value of Americans' 401ks. Then there are the tax hikes on conventional energy companies. The companies that produce the oil and gas that Americans use to heat their homes and to drive their cars. Increasing taxes on fossil fuel companies to the tune of tens of billions of dollars is pretty much guaranteed to discourage the additional energy production we need to drive down gas prices. Ironically, the proposals to go after traditional American energy production come from the same administration that is releasing oil from the Strategic Petroleum Reserve to deal with high gas prices. You can't make this up. Oh, and then there's inflation. Democrats helped create our current inflation crisis by sending a lot of unnecessary government money into the economy via the so-called American Rescue Plan. The President's budget would essentially do the same thing, which means our already serious inflation crisis could get even worse. Madam President, I mentioned the big spending increases in the President's budget. But what I actually meant are the big non-defense spending increases. Because while on paper it may look like the President is hiking defense spending, his supposed funding increase would be effectively canceled out by inflation. When you take into account Democrats' historic inflation, it turns out that President Biden's supposed defense spending increase could actually turn out to be a spending cut. Even in the best case scenario, his budget would leave defense spending essentially flat, which would leave our military dangerously underfunded. And that, Madam President, is a big problem. In a rapidly evolving threat environment, the last thing we can afford is a self-inflicted defeat from underfunding our military. Given Russia's war of aggression in Ukraine and threats to NATO and increasingly aggressive China, Iran's nuclear ambitions, North Korea's uptick in missile tests, and the Taliban taking over in Afghanistan, among other things, President Biden should be taking national defense spending at least as seriously as domestic spending. But he's not. The Biden budget proposal would leave the Army, Navy, Marine Corps, Air Force, and Space Force under-equipped and undermanned, and put our defense planning on a dangerously insufficient trajectory. The President's budget also fails to adequately address border security and immigration enforcement. Almost since the day the President took office, we've been experiencing an unprecedented flood of illegal immigration across our southern border. In fiscal year 2021, the Border Patrol encountered more than 1.7 million individuals attempting to cross our southern border, the highest number ever recorded. We've had 12 straight months of border encounters in excess of 150,000. And the surge is likely to get even worse now that the President has rescinded the Title 42 border policy to immediately deport individuals illegally attempting to cross the border. And what is the President's answer? Well, a $150 million cut to the U.S. Immigration and Customs Enforcement for next year. That's right. We're experiencing an unprecedented surge of illegal immigration, and the President's budget would cut funding to Immigration and Customs Enforcement. Madam President, perhaps the most outrageous thing about the President's budget is the way he misrepresents it. He's now trying to portray himself as somewhat fiscally responsible, as if a 66% higher yearly average spending than the last 10 years could be considered fiscally responsible. The President's talking a lot about deficit reduction, both the deficit reduction he has supposedly created and the deficit reduction his budget will supposedly produce. But the actual numbers, well, again, they tell a very different story. The deficit reduction the President would like to take credit for is partly the result of the end of temporary COVID spending measures, which were scheduled to end whether the President lifted a finger or not. And our current deficit would have been a lot lower if the President hadn't decided that we needed a partisan $1.9 trillion spending spree last year, a spending spree entirely made up of deficit spending. When it comes to the President's 2023 budget, the administration claims, and I quote, "Deficits under the budget policies would fall to less than 1/3 of the 2020 level the President inherited," end quote. Well, the key phrase there, Madam President, is the 2020 level the President inherited. 2020 saw a huge but temporary surge in government spending to deal with the onset of the COVID crisis. As a result, it is grossly deceptive to take the 2020 deficit as a baseline. A more honest assessment of the prospects for deficit reduction under the President's budget would look at pre-COVID deficits as a baseline and compare the President's future deficits to those. But that wouldn't suit the President's purposes. Now that it's become apparent that the American people are not in fact thrilled by far-left Democrat governance, the President is eager to portray himself as a moderate, hence his inflated claims of deficit reduction. It's the same reason the President is touting his supposed spending hike on national defense while conveniently omitting the fact that when you figure in real inflation, the spending hike may actually be a spending cut. Madam President, no matter how the President tries to dress it up, his fiscal year 2023 budget is more of the same far-left priorities. More taxes, more unnecessary spending, and more economic pain for the American people. And I hope, Madam President, I hope my Democrat colleagues will think twice before foisting this budget onto hardworking Americans. Madam President, I yield the floor. I suggest of a quorum.
Clerk, call the roll. Ms. Baldwin.
Madam President.
Senator from Massachusetts.
Madam President, are we in a quorum call?
We are.
I would ask unanimous consent for the quorum call to be vitiated.
Without objection.
Thank you. Madam President, I have 8 requests for committees to meet during today's session of the Senate. They have the approval of the majority and minority leaders.
Duly noted.
Madam President, I rise to speak in support of the nomination of Judge Ketanji Brown Jackson to serve as an Associate Justice of the United States Supreme Court. When confirmed, Judge Jackson, who currently serves on the U.S. Court of Appeals for the District of Columbia Circuit, will take the seat on the Supreme Court that Justice Stephen Breyer has held for almost 3 decades. So I'd like to first offer a few words about Justice Breyer as he prepares to step down from the bench. Justice Breyer has served the court and the nation with grace, expertise, humility, brilliance, and an unwavering dedication to justice. He has worked tirelessly to build consensus among his colleagues, and he has always kept in mind the real-world impacts of the court's decisions on the American people. Justice Breyer knew that justice for some was a failure of the court. From his opinions on voting rights to reproductive rights to the Affordable Care Act, he has been a key voice in many historic decisions that have affected so many Americans. We owe him a great debt of gratitude, and I'm honored and privileged to call Justice Breyer a dear friend, and I wish him the best in his retirement. Now, in looking for Justice Breyer's successor, President Biden said that he wanted to nominate a persuasive justice, someone in the mold of Justice Breyer. And with Judge Ketanji Brown Jackson, President Biden has found that person. I am confident that Judge Jackson, who clerked for Justice Breyer on the Supreme Court, will follow in his footsteps as a justice who will make a lasting contribution on the court through her pragmatism, even-handedness, and deep understanding of the Constitution and the impact that the court's decisions have on all Americans. And as the first African-American woman justice on the bench, Judge Jackson's historic nomination is an important and long overdue step towards making the Supreme Court better reflect the nation whose people the court serves. 54 years ago yesterday, our nation, our world, lost the guiding light of Dr. Martin Luther King Jr. to assassination. That loss was incalculable. We can only imagine the society we would live in if Dr. King was still with us, preaching, marching, teaching. And I have no doubt that Dr. King would be on the steps of the Capitol as the loudest and proudest voice in support of Judge Ketanji Brown Jackson to be our next Supreme Court Justice and the first Black woman to serve on our highest court. He would know that with the appointment and confirmation of Judge Jackson, we would take the long overdue step to make the nation's top court look more like and better represent all of the American people. The legacy of the more just, more equal society that Dr. King pushed us to create is alive, and it's well in this confirmation and on the floor and hearing rooms of the United States Senate this week. The Judiciary Committee held 4 days of hearings on Judge Jackson's nomination, including 2 days of testimony from the judge herself. As we all saw, some of the questioning of Judge Jackson from some of my Republican colleagues was nothing short of offensive, distorting her record and tinged with racism and sexism. But Judge Jackson responded with poise. She responded with brilliance. She calmly addressed and corrected her questioner's false and misleading premises. And she did so while demonstrating deep knowledge of the law and the Constitution, respect for precedent, and displaying precisely the kind of temperament we expect of someone sitting on the nation's highest court. The hearings showed the nation that Judge Jackson possesses all of the essential qualities of a jurist committed to the words engraved above the entrance to the Supreme Court itself: equal justice under law. Of course, to anyone who knew Judge Jackson before her introduction to the nation as a Supreme Court nominee, none of this was surprising. Judge Jackson's qualifications to serve on the Supreme Court are second to none. She holds broad experience across the legal profession as a Supreme Court clerk, as a federal public defender, and as an attorney in private practice, and as a member of the United States Sentencing Commission, as a federal district court judge, and as a federal appellate judge. It was therefore surprising to no one that she earned a unanimous, well-qualified rating from the American Bar Association. Let me speak for a moment about one aspect of Judge Jackson's background that stands out, and that is her experience as a public defender. When confirmed, Judge Jackson will become the first ever justice with background as a public defender, and the first justice with significant criminal defense experience since the service of Justice Thurgood Marshall, who retired in 1991. That work as a federal public defender has unjustly come under attack from my colleagues across the aisle, who suggest that being a public defender means that she is soft on crime. But my Republican colleagues, who far too often focus singularly on the constitutional right to bear arms, would do well to remember that among the Constitution's other enshrined rights is the Sixth Amendment's right to counsel in criminal cases. Without that right, criminal defendants who cannot afford an attorney would find it difficult or impossible to navigate the court system with their rights protected, including the fundamental right to a speedy and fair trial. My Republican friends may also want to consider that Judge Jackson comes from a law enforcement family with a brother and uncles serving as police officers, and that she has won the endorsement of the Fraternal Order of Police, the nation's largest police union. And let me remind my colleagues that public defenders do not select their clients. They take on every assigned case because they are committed to preserving and defending constitutional rights for everyone. As a federal public defender, Judge Jackson represented the most vulnerable among us. She represented the clients other lawyers avoided. And in doing so, she followed a long and honorable tradition in the American legal profession that began with John Adams, stepping forward in 1770 to represent the British soldiers who committed the Boston Massacre, because he feared that they would not receive a fair trial without adequate representation. By confirming Judge Jackson, we will affirm that the rights of those who cannot afford a lawyer are just as important as the rights of those who can pay lawyers charging $1,000 an hour. That the rights of the indigent and powerless are just as important as those of the rich and the powerful. Public defenders also experience firsthand and therefore understand better than other lawyers just how our justice system treats the accused, how it treats people of color, how it treats low-income people. Every day, public defenders see the systemic biases and prejudices that permeate our criminal justice system. At a time when the United States holds more people behind bars than any other nation on earth, including authoritarian regimes like North Korea and China, the highest court in the land would greatly benefit from a justice with a public defender background. Public defenders serve as a unique bulwark of liberty and racial justice. So we should welcome a public defender on the Supreme Court, especially one as well qualified as Judge Jackson. Her singular perspective and voice are sorely needed. Judge Jackson's service as a trial judge on the United States District Court for the District of Columbia is also of particular note in this nomination. Only one of the current Supreme Court justices, Justice Sotomayor, has ever served on a trial court. And as a trial court judge, Judge Jackson worked to ensure that the parties before her understood her approach to deciding cases. Judge Jackson has explained that as a trial judge, she emphasized speaking directly to the individuals who appeared before her, not just to their lawyers. She used the parties' names and treated them with respect. She sought to ensure that those whom her rulings would directly impact clearly understood the proceedings in which they were involved, what was happening, and why it was happening. This approach speaks to a judge who understands the importance of accessibility to the law, to a judicial process that isn't shrouded in mystery, and to a system that fulfills its promise of equal justice under the law to everyone. We will be fortunate to have such a justice on the Supreme Court of the United States. I have had the opportunity to meet with Judge Jackson one-on-one. I came away deeply impressed and convinced that President Biden has made a great choice. The Senate has already confirmed Judge Jackson 3 times on a bipartisan basis, most recently in June of 2021, when she was confirmed to the D.C. Circuit. The Senate should again confirm her with bipartisan support. And when Judge Jackson is confirmed and becomes Justice Jackson, the first African-American woman ever to take a seat on the High Court, she will be an inspiration to so many across our country and around the globe. She will especially be a role model for young black girls everywhere, showing them that in the United States of America, nothing is beyond their reach. Supreme Court Justice Thurgood Marshall once said, "Sometimes history takes things into its own hands." History says it's time for Judge Ketanji Brown Jackson, and I am honored to help her and the court and our country make history with her confirmation. I urge all of my colleagues to vote to confirm Judge Ketanji Brown Jackson to the Supreme Court of the United States of America. Madam President, I yield.
Say what I was like, and it was coming. I was just like.
Madam President.
Senator from Arkansas.
Thank you, Madam President. I rise today to recognize the significant legislative victories the Senate recently delivered for women veterans with the passage of 2 pieces of legislation to modernize breast cancer screening policies and the delivery of life-saving care for women veterans. Breast cancer is the 2nd most common cancer for women. For women veterans and service members, the incidence of breast cancer is estimated to be up to 40% higher than the general population. Given the dangerous environments in which military members serve and additional risk factors associated with these locations, it's long overdue for the Department of Veterans Affairs to update its policies for administering mammograms. We know early detection is crucial to preventing and treating breast cancer, so making sure those who are more vulnerable receive screenings at a younger age is not only reasonable but critical. This would have helped Dr. Kate Hendricks Thomas, a Marine veteran who was unaware of her increased risk for breast cancer. She shared her memories of deployment to Fallujah in 2005 with the Senate Veterans Affairs Committee last year. She understood the risk associated with IEDs, and she remembers the burn pits, so commonplace they were largely ignored. But she wasn't concerned with the impact of what she called, quote, the flaming poison, end quote, surrounding her would have on her own health. In a routine medical appointment with her VHA health provider in 2018, Kate thought it was odd she was recommended to undergo a mammogram. That exam subsequently led to her diagnosis of stage 4 breast cancer. She was 38 years old. That's devastating news for anyone to face, and I know the entire Senate joins me in praying for Kate as she continues her fight against cancer. Nobody would blame her for focusing on her own health battle, but she knows her story wouldn't be the last if something didn't change. That's why Kate has been an advocate for modernizing VA policies so other veterans don't experience the same struggles she's living with. We honored her activism by crafting and passing the Dr. Kate Hendricks Thomas Supporting Expanded Review for Veterans in Combat Environments Act. It will broaden veteran access to mammograms and also require the VA to compile data regarding the rates of breast cancer among members of the veteran and civilian population so we can continue improving procedures to better treat breast cancer patients. The Senate also unanimously passed the Mammo for Veterans Act to expand access to high-quality breast cancer screenings, improving imaging services in rural areas, and clinical trials through partnerships with the National Cancer Institute. The VA is uniquely positioned to be a leader in the prevention and treatment of breast cancer, taking full advantage of the department's unique capabilities, resources, and outreach will help deliver the life-saving care that veterans deserve. Passage of the Dr. Kate Hendricks Thomas Service Act and the Mammo for Veterans Act reflects the bipartisan support for improving veteran services and benefits. I appreciate Senator Wyden's support and leadership of the Senate Veterans Affairs Committee and the leadership of the Senate Veterans Affairs Committee Chairman Tester, who's been my reliable partner in advancing policies to improve the VA's care and services for women. The VA estimates women make up 10% of our nation's veteran population and continues to be the fastest growing population. Last Congress, we made significant progress to expand VA's care and services for women with the passage of the landmark Deborah Sampson Act. This was an important first step, and the legislation we passed last month continues to build on this foundation so we can fulfill the promise made to women who served in our nation's uniform. I'm pleased the Senate has approved these policies, and I urge my colleagues in the House of Representatives to follow our example and quickly approve the Dr. Kate Hendricks Thomas Service Act and the Mammo for Veterans Act so that they can be signed into law. The women who have served our country in uniform need to know we're taking every step available to protect their health. These bills are an important down payment in that mission. And with that, Madam Chair, I yield the floor.
Senator from Illinois.
Madam President, I've come to the floor today to mourn the passing and celebrate the life of Thomas Horace Porter, my good friend and a man who could put a smile on my face even in the toughest times on one of the most painful days of my life while I was recovering at Walter Reed. Among the peer visitors at Walter Reed Hospital, two of the most beloved were Tom and his wife Eleanor. Tom was a gentle giant, a tall, smiling, then 74-year-old veteran who showed up at my bedside while I was still sedated to talk with my husband and mother, and who came to visit again soon after I regained consciousness. As a young Army lieutenant in the Korean War, Tom had lost both his legs in a landmine explosion. His heroic actions saving his men on that day earned Tom both the Silver Star in addition to the Purple Heart from his combat injuries. During his months of recuperation back in the States, Eleanor, or Elle, as we all know her, an Army second lieutenant herself, had been one of his physical therapists. The couple ended up married for more than 50 years. Tom continued to serve our nation, this time as a civil servant, achieving the rank of Senior Executive Service in the Department of Agriculture. When Operations Iraqi Freedom and Enduring Freedom began and the wounded began flooding the wards at Walter Reed, Tom and Elle decided that they needed to help. They became peer visitors, and for the next 7 years, during twice-weekly visits, they changed the lives of countless veterans who passed through that hospital, my own included. When I was at Walter Reed, Tom made it his mission to talk with injured troops about the full lives they will lead after their devastating injuries. A lot of the wounded warriors around me were really young, just 19 to 24 years old, lying in their hospital beds with limbs missing, burns to their faces and bodies, skulls crushed and encased in protective metal cages or helmets. They were all facing a future none of them had planned for. Like them, I had always assumed I would either die in combat or come home. The third option of coming home severely injured was never something that occurred to the majority of us. Tom would walk in with that big smile of his and say, "Hey, I was like you, lost my legs at 22, but I recovered and have had a full and regular life. I courted Elle after I lost my legs, and she and I have been married for 50 years and have wonderful kids and grandkids." He reassured them that they could still have the lives they dreamed of, and his words had weight because he was living proof that that was possible. He'd wink and joke, "Listen, having an amputation is better than having a puppy. Trust me, you won't have any trouble getting the ladies." And then he'd answer any questions they had because he knew they needed to hear from someone who had already journeyed on the road they were about to travel. For years, Tom and Elle came into Walter Reed every Tuesday and Thursday without fail. Elle was known as the cookie lady because she'd bring in dozens of homemade cookies that she collected from folks at her church. For those of us who were in the hospital a long time, Elle knew our favorites. Mine were oatmeal raisin. If I was at physical therapy or in surgery or getting my wounds debrided, when Elle made her rounds, she'd make sure to leave a little bag of cookie by my bedside table. It was a real treat in the midst of the painful early stages of recovery, something to look forward to every week. Tom and Elle and Tom, the two of them became family for all of us. They would bring me and my husband to their lakeside home, feed us home-cooked meals, and let me fall asleep in their hammock overlooking the water, knowing the good that getting out of that fluorescent-lit hospital room would do me. As someone who loved and was desperately missing the ocean, I can't begin to describe how restorative those days by the lake were. There are no words for how right it felt to be drifting off to sleep to the sound of waves hitting the shore rather than to the beeps and the buzz of the hospital machines that had been my nightly soundtrack for too long. And there's no possible way to express just how grateful I am to Tom and Elle for making that a possibility. For giving me a taste of home right when I felt most like a stranger to myself. For enveloping me in something good and whole right when I felt untethered from what I felt was my life's mission. And for simply being who they were, kind and fierce, as compassionate for the people they loved as they were passionate about the causes that they believed in. They were our advocates, our heroes, our Tom and our Elle. I'm so sorry for your loss, Elle. We miss Tom every single day. Thank you both for all you did for me and what you did for all of us. We miss you desperately. I yield back, Madam President.
Madam President.
Senator from Rhode Island.
Thank you, Madam President. Madam President, we are debating the President's nominee to succeed Justice Stephen Breyer, who has served this country admirably and with great distinction. As a law student, I was fortunate to have Justice Breyer as an advisor, and I remain grateful for his guidance, encouragement, and counsel as I began my legal career. I have immense respect and admiration for him as Justice, but even more so as a person. When Justice Breyer announced his retirement, I stated my belief that the next justice on the Supreme Court should be someone with Justice Breyer's integrity, independence, and keen intellect, someone with real-world experience who reflects the depth and breadth of the American people. You could not find someone who better fits that description than Judge Ketanji Brown Jackson. And I rise today in wholehearted support of her nomination to the Supreme Court. The Supreme Court is a powerful arbiter of justice in our nation, with few checks on the decisions of the justices once they are on the court. Therefore, a vote on a Supreme Court nominee is one of the most consequential that any senator can cast. The Constitution makes the Senate an active participant, along with the President, in the confirmation of a Supreme Court justice. Article 2, Section 2, Clause 2 of the Constitution states that nominees to the Supreme Court shall only be confirmed by and with the advice and consent of the Senate. The Senate's role in the confirmation process places an important democratic check on America's judiciary. As a result, this body's consent is both a constitutional requirement and a democratic obligation. It is in upholding our constitutional duties as senators to give the President advice and consent on his nominations that I believe we have one of the greatest opportunities and responsibilities to support and defend the Constitution of the United States. As I have stated before, my test for a nominee is simple and is drawn from the text, the history, and the principles of the Constitution. A nominee's intellectual gifts, experience, judgment, maturity, and temperament are all important, but these alone are not enough. I need to be convinced that a nominee to the United States Supreme Court will live up to both the letter and spirit of the Constitution. The nominee needs to be committed not only to enforcing laws, but also to doing justice. The nominee needs to be able to make the principles of the Constitution come alive: equality before the law, due process, full and equal participation in the civic and social life of America for all Americans, freedom of conscience, individual responsibility, and the expansion of opportunity. The nominee also needs to see the unique role the court plays in helping balance the often conflicting forces in a democracy between individual autonomy and the obligations of community, between the will of the majority and the rights of the minority. A nominee for the Supreme Court needs to be able to look forward to the future, not just backwards. The nominee needs to make the Constitution resonate in a world that is changing with great rapidity. Judge Jackson passes these tests with flying colors. Beyond her unquestioned intellectual gifts, her legal career over the past 2 decades demonstrates that she has the deep fidelity to equality, justice, and the Constitution required to be our next Supreme Court justice. We want justices to be familiar with the federal court system. Judge Jackson is. Indeed, soon after law school, Judge Jackson chose to clerk at 3 levels of the federal courts, gaining valuable insights into the courtroom and learning directly from incredible jurists, including Judge Bruce Sellier of Rhode Island, who was President Reagan's nominee to the U.S. Court of Appeals for the First Circuit, as well as for Justice Breyer himself. We want justices to understand that a guilty verdict involves a hard task of deciding the appropriate punishment. So while many of her law school classmates likely plotted paths to law firm partnerships, she chose instead to serve as assistant special counsel and later commissioner and vice chair at the U.S. Sentencing Commission, working to prevent unjust disparities in sentencing. We want justices to embody the fundamental notion of fairness as the heart of our justice system, that defendants have a right to counsel and must be proven guilty beyond a reasonable doubt. And so Judge Jackson chose to serve as a federal public defender. If confirmed, she will bring this valuable real-life perspective to our highest court, where it is very much needed. Over the past 10 years, First as a district judge and then as a circuit judge, Judge Jackson has been even-handed and impartial in her decisions from the bench, without regard to partisanship, personal views, or ideology. Her opinions showcase an admirable commitment not only to fairness but to transparency. She takes the time to ensure that the parties fully understand her rulings and that the record clearly captures her thought process in deciding a case. She does not hide the ball. There are facts, there are arguments, and everyone is invited to read and understand them. Beyond her career choices and accolades, she demonstrated her judgment, maturity, and equanimity during her recent confirmation hearings. In the face of hours of questioning, some of it quite pointed, political and discomforting, she showed incredible patience, resilience, and grace. Her independence, integrity, and deep understanding of the Constitution shine through in her answers. Her cool in that crucible was not only admirable, it was inspiring. Judge Jackson is a trailblazer, not in the least because she is the first black woman and first federal public defender nominated to the Supreme Court. While her individual accomplishments are personal, Judge Jackson's elevation to the United States Supreme Court will bring America closer to the ideals our country aspires to. Her service on the Supreme Court in the years to come will ensure that the justices better reflect the diversity of our great nation and may help restore the people's faith in the fairness of the court and in our justice system. It is with great pleasure that I support her nomination to the highest court in the land and urge my colleagues to do the same. With that, Madam President, I would yield the floor, and I would notice the absence of a quorum.
Clerk, call the roll.
Ms. Baldwin.
Madam President.
Senator from Wyoming.
Thank you, Madam President. I ask unanimous consent that the quorum call be vitiated.
Without objection.
Thank you, Madam President. Madam President, I come to the floor today to talk about the need for more American energy. On Thursday, President Biden announced that he's going to release even more oil from the Strategic Petroleum Reserve. To me, this is another desperate Hail Mary pass. It's a short-term effort to deal with their midterm election crisis. It's a crisis that's been created by the policies of this administration. Real crisis is the cost of living crisis, and it's a crisis that is punishing American families. Inflation's at a 40-year high. Gas prices recently hit the highest price ever. Why is it happening? It's Economics 101. The supply of energy is not keeping up with the demand for energy. We're now producing about 1.3 million barrels of oil per day fewer, less than we were in 2019. Yet for the last 14 months, Joe Biden's been in the White House. He has done absolutely nothing to increase the supply of American energy. Not sold one lease to produce energy on public lands. Not one. President Obama, at this time into his first term, had already held 47 federal lease sales in his first 14 months in office. For Joe Biden, the number is still 0. Now, this just shows that when it comes to energy, Joe Biden is to the far, far left of any previous American president. Joe Biden is already the most anti-American energy president that we've ever had. He refuses to do any of the things that would actually help our country in terms of our energy needs. He won't increase oil production by a single drop. No, he wants to release some from the Strategic Reserve, but not actually produce any more American energy. So what he's essentially doing is burning through our savings account. This is now the third time that President Biden has released energy from the Strategic Reserve. He's on pace to burn through a third of our oil savings in less than 2 years in office. Soon we're going to have the smallest amount in our reserve, the smallest amount in our savings account since 1984. In November, Joe Biden conducted the largest release from the Strategic Reserve in history. He released 50 million barrels. So what was the result? He made a big announcement of it. The Secretary of Energy did as well. The price of gas went down by 2 cents. 2 cents. The White House was so proud of themselves that they actually sent out a press release congratulating themselves. Prices went back up almost immediately. The result was an utter failure. So now Joe Biden said he's going to release 180 million barrels over the next 6 months, 1 million barrels a day for the next 180 days. In other words, between now and right before the elections. The Strategic Reserve is meant for emergencies. It's not meant for cynical political cover-up of what the president has done to our American energy policy. Some people call it an election year gimmick. I call it dangerous. Dangerous because we're going to be less prepared for emergencies, we'll be less secure, and as a nation, we will be less safe. Now, 180 million barrels sounds like a lot. It's about the amount we use in an average of 9 or 10 days. We use about 20 million barrels a day in the United States. We're currently importing a lot more than that. Even the president admits that it won't have a big impact, but he doesn't know what else to do. On Thursday, he said this would reduce prices by as little, he said, as 10 cents a gallon. We're still over $4 a gallon nationwide in terms of the national average. I expect it's going to remain that high, over $4 a gallon, through the summer. So who do the American people blame for this? Well, poll after poll, they blame Joe Biden because he's the one that proudly stood there and beat his chest and said, I've killed the Keystone XL pipeline. The day Joe Biden took office, gasoline $2.38 a gallon. America was energy independent for the first time in 70 years. We were energy dominant. We were exporting energy. We were selling it to our friends instead of having to buy it from our enemies. Joe Biden took office, started attacking American energy, and things deteriorated ever since. That's why it's no surprise that energy and gas prices are up 13 out of the last 14 months. By the time Vladimir Putin invaded Ukraine, the average price of a gallon of gas had gone up from $2.38 a gallon to $3.53 a gallon. So it was already up over $1.15 a gallon in just over that first year in office for President Biden. Today, the average price of a gallon of gas is about $4.18. Prices may actually go higher if Joe Biden gets his way in terms of energy policy. That's because when the president put out his budget, he wants to raise taxes on American energy. The budget that the president has proposed for the next year contains 36 new taxes. 11 of them are directly on American energy. It costs about $45 billion, which of course would be carried on to the people who buy American energy. They'd be paid by working families in the form of higher gas prices, higher oil bills, cost more to heat your home. Even Nancy Pelosi, when she looked at the budget, said, quote, consumers pay for that. On Thursday, Joe Biden asked Congress to charge fees on oil and gas leases that aren't even being used. Now, this is another gimmick. People want to use those leases, but the administration is blocking the permission to drill to use the leases. This is just a continuation of the Biden blame game. So if you want to explore for energy in America, the lease is just the first step, the first of many. You need to apply for permit to drill. In Wyoming, people know all about this. They call it APDs, the application for the permission to drill. You have to pay to apply after you paid the rent on the lease. So you apply, somebody has to make a decision. Those decisions used to be made at the local level. Not anymore. Now the Biden administration said, we know better than any of you people out around the country. We'll make all the decisions out of Washington, and the decision they made is they're not going to give any of these permits to drill. That's why the president can say, well, they're not drilling. Well, you're not letting people drill. Now, we're not talking about a couple leases. We're talking about thousands and thousands, over 4,000 leases tied up that way. We have another group of leases that are tied up by environmental activists who love to sue to stop energy exploration. They want to keep it in the ground. So companies are paying their rental fees. They want to explore for energy. They're being blocked by the administration, and then they're being blamed by that same administration for not exploring for energy. The president says, well, use it or lose it. Well, that's the law of the land right now. If it doesn't produce oil or gas within 10 years, you actually lose the permit. He doesn't want to explain that to folks. Now, if the lease does produce energy, does produce oil, then the government actually reaps the benefit from that. They get tax money from that. That helps pay for many of the things that we do as a government. In Wyoming, in our state areas, we use it to help with the paying for education, pay for health care. Vital services in the community paid for by the successful exploration and recovery of energy that is currently underground, that Joe Biden wants to keep underground. Now in the president's budget, he wants to charge an additional fee on top of all of this. So he refuses to let them drill. He wants to charge them for not drilling. This is something out of Alice in Wonderland. More fees will mean produce less. We need to produce more. That's a way to get down the price at the pump, produce more American energy. Democrats refuse to admit that the percentage of leases that are actually being used today has never been higher. These are old leases. Democrats' excuses on this issue are what I would put in the category of the big lie. The big lie to support an anti-American energy agenda. It's an agenda of less American energy, more taxes, higher prices. It's a reason why millions of American families today are struggling to get by. They're feeling the pain. According to one estimate from the economist at Bloomberg, American families will spend an extra $5,200 this year. That's $100 a week compared to last year to just stay even. It's all due to inflation, the cost of groceries, the cost of gas, the cost of goods. All of those things are squeezing the American families. People are being crushed. Their dreams are being crushed. Potential savings to send kids to college, that's gone away. Savings for a vacation, that's going away. You got to empty your wallet to fill your tank under Joe Biden's energy policies. And the extra $100 a week, this is on top of last year's inflation, where people across the country said they were paying more and more to get less and less, and even if they got a raise, they couldn't keep up. Kept falling further and further behind. People across the country are already living paycheck to paycheck. They can't afford more price increases. They need real solutions, and they are not getting them from this White House. The answer seems pretty simple. Stop the reckless spending here in Washington, unleash American energy. So President Biden needs to do a couple of things right away to unleash American energy. First is a long-term commitment to produce more American energy. Energy companies aren't going to invest if they think Joe Biden is going to shut them down tomorrow. And he said that's what his goal is in a recent speech. He wants them to produce more today so he can shut them down tomorrow. He does need to open up our federal lands. We should auction off leases right away. And Joe Biden should approve those 4,600 drilling permits, which today are still stuck in limbo. He put them there, locked them in. It takes months to get production up and running. Got to get the right permits, got to have the pipelines. Need to speed up the process for pipelines as well. Although we did see the Federal Energy Regulatory Commission, all of the commissioners come to the Energy Committee, and they don't seem to be very interested. At least the ones in the majority don't seem very interested in speeding up the pipeline process or allowing pipelines at all. And finally, Joe Biden needs to stop attacking the hardworking men and women of this country who continue to produce energy, who go to work every day to keep the lights on, to keep us warm in winter. We need these workers out there, and Joe Biden needs to stop attacking them on a daily basis. They're the ones who can get us out of the crisis. They're the ones we need for the economic recovery. Instead of spending our savings, it is time to unleash American energy. Madam President, we need more American energy, and we need it now. Thank you, Madam President, and I yield the floor. Suggest the absence of a quorum.
Clerk, call the roll.
Ms. Baldwin.
Madam President,
Majority Leader?
are we in a quorum?
We are.
I ask unanimous consent the quorum be dispensed with.
Without objection.
Madam President, I ask that the Senate resume legislative session and vote the motion to invoke cloture on the motion to proceed to H.R. 4373 under the previous order.
Without objection. The clerk will report the motion to invoke cloture.
Cloture motion, we, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close the debate on the motion to proceed to calendar number 310, H.R. 4373, an act making appropriations for the Department of State, Foreign Operations, and related programs for the fiscal year ending September 30th, 2022, and for other purposes, signed by 17 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is that the sense of the Senate, the debate on the motion to proceed to H.R. 4373, an act making appropriations for the Department of State, Foreign Operations, and related programs for the fiscal year ending September 30th, 2022, and for other purposes shall be brought to a close. The yeas and nays are mandatory in the rule. The clerk will call the roll.
Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Braun, Mr. Brown, Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Tuberville, Mr. Van Hollen, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Booker, Duckworth, Heinrich, Reed, Rosen, Schumer, Sinema, Stabenow, Tester, and Warren. Senators voting in the negative: Barrasso, Bozeman, Crapo, Johnson, Lankford, Lee, Lummis, McConnell, Romney, Scott of Florida, and Tillis. Ms. Ernst, no. Mr. Peters, aye. Mrs. Shaheen, aye. Mr. Hickenlooper, aye. Mr. Lujan, aye. Ms. Smith, aye. Mr. Thune, no. Mrs. Murray, aye. Mr. Sass, No. Mr. Cassidy, Mr. Cassidy, no. Mr. Cornyn, no. Mr. Brown, aye. Mr. Whitehouse, aye. Ms. Cantwell, aye. Ms. Collins, no. Ms. Baldwin, aye. Mr. Markey, aye. Mr. Hawley, no. Mrs. Capito, no. Mr. Murphy, aye. Mr. Casey, aye. Mrs. Blackburn, no. Ms. Hirono, aye. Mr. Warner, aye. Mr. Burr, no. Mr. Portman, no. Mr. Cardin, aye. Mr. Kane, aye. Mr. Schatz, aye. Cortez Masto. Ms. Cortez Masto, aye. Mr. Coons, Mr. Coons, aye. Mr. Leahy, aye. Mrs. Hyde-Smith, no. Mr. Kennedy, no. Mr. Braun, no. Mr. Scott of South Carolina, no. Mr. Carper, aye. Mr. Wicker, no. Mr. Risch, no. Mr. Padilla, aye. Mr. Cotton, Mr. Cotton, no. Mr. Rubio, no. Mr. Wyden. Mr. Wyden, no. Mr. Blunt, no. Mrs. Gillibrand, aye. Mr. Durbin, aye. Mr. Sanders, aye. Mr. Graham, no. Mr. Inhofe, no. Mr. King, aye. Mr. Haggerty, no. Mr. Shelby, no. Mr. Manchin, aye. Mr. Rounds, no. Mrs. Feinstein, aye. Mr. Ossoff, aye. Mrs. Fisher, no. Mr. Moran, no. Mr. Hoven. Mr. Hoven, no. Mr. Daines. Mr. Daines, no. Ms. Murkowski. Ms. Murkowski, no. Mr. Warnock. Mr. Warnock, aye. Mr. Kramer. Mr. Kramer, no. Mr. Toomey. Mr. Toomey, no. Mr. Cruz. Mr. Cruz, no. Mr. Marshall. Mr. Marshall, no. Ms. Klobuchar. Ms. Klobuchar, aye. Ms. Hassan. Ms. Hassan, Aye. Mr. Paul, no. Mr. Bennett, aye. Mr. Kelly, aye. Mr. Grassley, no. Mr. Sullivan, no. Mr. Tuberville, no. Mr. Van Hollen, aye. Mr. Young, no. Mr. Blumenthal. Mr. Blumenthal, aye. Mr. Merkley. Mr. Merkley, aye.
Mr. President.
The Majority Leader?
Yeah, for the purposes of reconsideration, I change my vote to no.
Mr. Schumer. Mr. Schumer, no.
Yep.
On this vote, the yeas are 47, the nays are 52. 3/5 of the senators duly chosen and sworn not having voted in the affirmative. The motion is not agreed to.
Mr. President.
The Majority Leader.
I enter a motion to reconsider.
Motion is entered.
And Mr. President, I ask unanimous consent to resume executive session.
Is there objection? Without objection.
Now, Mr. President, I want there to be no mistake about what just happened here on the Senate floor. Republicans blocked a bipartisan bill that would provide vaccines, testing, and therapeutics for the American people. Yesterday, a group of Democrats and Republicans announced we had reached a bipartisan agreement for COVID relief funding. But today, a majority of Senate Republicans have blocked this critical and much-needed funding from going forward. Vaccines, therapeutics, and testing were negotiated in good faith, and they should not be held hostage to extraneous, unrelated issues. This is too important for the health of the American people. But that seems precisely what some Republicans want to do. This is a potentially devastating vote for every single American who is worried about the possibility of a new variant rearing its nasty head within a few months. It is devastating for any American who in the future looks for a vaccine or a booster shot, only to be told supplies have run out. It is devastating for anyone looking down the line to get tested because they feel sick or want their families safe and discover no tests are available. It is devastating for anyone who, God forbid, falls seriously ill, but can't access life-saving therapeutics because the federal government can't purchase new supplies because of the vote our colleagues on the Republican side of the aisle just took. Too many Republicans seem to want to play politics at a time when we need to work together to pass legislation our country desperately needs. Republicans voted no on vaccines for kids. Republicans voted no on tests for new COVID variants. Republicans voted no on therapies to save lives and make us less sick. Have we learned nothing from the last 2 years of living with this horrible disease? Have Republicans learned nothing about how lack of preparation could damage our economy? This money, the money that they rejected today, will go a long way to keeping our schools, our businesses, our churches, our communities running as normally as possible. If we want to stay at normal, we need these dollars. Without these dollars, the risk of schools closing, of businesses closing, of public transportation closing is too large. Should a future variant rear its nasty head, Americans will know who voted against more funding. An ounce of prevention is worth a pound of cure. This was a $10 billion agreement that was fully paid for. If there's another surge, it cost us 10 times that if we're behind the curve again. I hope Republicans will get serious about this. It should not be so difficult for them to do something so good and important for our country. There's still some time. I hope my Republican colleagues change their tune quickly. I yield the floor.
Senator from Colorado.
Thank you, Mr. President. I appreciate the opportunity to address the Senate on an issue of real importance to our country and to families in Colorado and all across the United States. Today, 120 economists wrote an open letter in the face of the inflation that we're now facing as a nation as a result of the economic growth that we are having coming out of this very deep recession and the supply chain interruptions that have caused inflation. 120 economists sent an open letter saying that, quote, the expanded child tax credit is one of the easiest, most effective, and direct tools currently at our disposal to help families deal with the impact of inflation on family budgets. The expert opinions about the causes of and solutions to rising inflation are as varied as the authors of this letter, they wrote, but we agree on this. We agree on this. The expanded child tax credit is too small to meaningfully increase inflation across the whole economy. That means that the $100 billion a year that the child tax credit costs to lift half the kids out of poverty isn't going to drive inflation in a $21 trillion economy. That's one of the points these economists agreed on. But they wrote, it will make an important difference for family budgets, especially families in the bottom half of the income spectrum. Monthly child tax credit payments are a proven success at helping families keep up with the everyday costs